Ladies and gentlemen, I can't quit. I can't leave this courtroom. Got to do my job in this case. Mr. Toledo does. I can't just, after that opening statement, all the information that I've seen, the photos, the smiling picture of Gannon, hearing about him being shot and stabbed multiple times. Hundreds of witnesses and 800 pieces of evidence that are going to come in. I can't check out now and just sit down and write this out. I can't do it because it wouldn't be fair. Wouldn't be fair to the court system, the process, and it wouldn't be fair to Ms. Stauch. And I know people will say, well, who gives a shit about what's fair for Ms. Stauch? The court systems do. The law does. The Constitution, the Bill of Rights. The war fought over these things that we're dealing with today. Old school laws, presumption of innocence, right to remain silent, stuff that comes all the way back from old Boston and Paul Revere riding through the streets on his horse going, the British are coming, the British are coming. Old stuff, and it matters. And once we decide something in the media, before you have heard one shred of evidence, prejudge this case before anything has taken place, then all of that is lost. And we are truly a country that is no longer ruled by law, but by the media. I get it, we've lost. Mr. Sweeney, we lost. Stout, we lost. We have lost in the court of public opinion and the media. He's guilty. I get that. This is a court of law. As Judge Werner said, come through those double doors there. This is a special place. This isn't the media. This isn't Facebook. Wash all of that away. Don't try to get up and walk out of the courtroom before you started. Do your jobs. Listen to the evidence. When the evidence is complete, go back into the jury room and weigh the evidence. All I'm asking of you, just give us a fair shake. I can see it in your eyes, ladies and gentlemen. A lot of you, as far as you're concerned, I could burn in hell for representing Ms. Stauch. A lot of you won't even make eye contact with me. I might as well just be the devil himself up here running his mouth. But I'm not. No different than those three at that table right there. Paid advocates. Warner here in voir dire says they are paid advocates. Amy and I were paid advocates. They have their side of the story. And I just want to be heard. Want our side to be heard. And if at the end, guilty, but you weighed the evidence, you listened, you didn't prejudge the case, your biases, your sympathies, your prejudices that you had at the beginning of this trial, if you didn't let those come in, were fair and impartial, but it's still guilty, I'll take that. I'll take that in a case like this. A lot of evidence. Very, very difficult case. So don't quit on me. Now, Mr. Allen is right. He's a good attorney. He's well-spoken. He elected DA. This is going to come down to insanity. Here. And was killed back in January 20. How do you figure that out? How do you look into the mind of a sick person and divine what they are thinking? Well, evidence, people's statements, observations, recorded statements, phone call, heard Ms. Stauch talking on. That's good stuff. What else can you look at? Motive. Somebody's motive. Remember that word? Up every day during jury selection for the past 2 weeks by the prosecution. Motive. You were told, and rightly so, by the prosecution that there is no requirement for the prosecution to prove motive. They're right. Does that mean that motive doesn't matter? No, it doesn't. Not mean that. Even the own jury instruction talking about insanity, the prosecution just put up on the board, talked about motive or lack of motive could be a sign that there is insanity or not insanity. And it's in the jury instruction there. So it does matter. It's not required, but it matters. And it matters because it's evidence. You don't have a motive, that goes to show a lack of evidence. Say there's a couple people involved in a shooting and a murder out in the community. Paper reports it as a random, senseless act of violence. One person shot to death. Police investigate. They have 3 people that are suspects that were there at the scene at the time of the shooting. One problem for the investigators. Don't really have any other evidence. A week later, doing some good police work, they uncover that one of the three people was a drug dealer who was ripped off the week before the shooting by the dead man. A lot of money and drugs were stolen. All of a sudden, with that information, this random, senseless act of violence becomes a murder with a motive. It does matter.
You need to put it up. It's not hooked up yet. You can turn off the perimeter lights if you want. I'm not getting the feed come through. You are hooked up to the defense. Still not coming through. Oh, there you go. That's what you're looking for, right?
That's the photo. Ladies and gentlemen, if you will turn your attention to the two boards, screens. This fancy pointer that you were alluding to, Judge. Extendable. All right, we've got a photo here. We've got some familiar looking faces. Gannon, Letesha Stauch. Stepmom, stepson. Gannon's little sister in the back. Look at that. Looks like everybody's doing pretty good. Happy, sunny day. Maybe Miss Stauch is doing a selfie, holding the camera out. Whatever. When would have this photo been taken? The day before Gannon died. The day before he was killed. It wasn't a photo of evil, anger. A photo of someone, by all accounts, who was a loving stepmother. Care of Gannon. Gannon's father was on a deployment. Stauch worked as a teacher herself in the Whitefield School District, an elementary school teacher. Got a person that was, living would seem like the American dream in a nice suburban house in Lorson Ranch, the suburbs of Colorado Springs, Colorado. But behind those photos and Miles, Stauch. Oh,
Yeah, I did.
okay. Stauch was hiding. Stauch was dealing trauma and abuse that had been going on since she was a toddler. A troubled childhood. Mother wasn't really much of a mother. she had a line of stepdads or boyfriends or whatever. Her mother come in and out, come in and out, in and out, in and out of her life. From the time she was 3 or 4 years old, Miss Stauch, until she finally moved out. And she suffered. She suffered horrifically from these stepfathers, these boyfriends of her mother. Watched her mother get beat by the boyfriends, physically abused, till eventually the physical abuse these men reserved for her mother eventually trained on the Stauch here. Girl. First, it was just physical beatings, whoopings, emotional abuse, verbal abuse, and then it became sexual, where she was molested regularly. Five or six until she was a teenager. Constant. She used to have to sleep in the car out in the driveway to get away, not have to molested and sexually assaulted by these men. Sleep in the car in the driveway of her house. Because her mom wasn't around a lot, kind of an absentee mom, a lot of these stepfathers, if you could call them that, cared for Miss Stauch exclusively. Mom was out somewhere doing something, gone for several weeks at a time. And Miss Stauch, as a young child and a young woman and a teenager, was left in the care of these men. How do you deal with this? You're 6, you're 7 years old. What do you do? Physical abuse, sexual abuse, emotional abuse. How does a kid handle that? Well, a lot of people that have had bad childhoods go on and they're fine. There's some that don't. Some is a survival mechanism. Some of these children's personalities fragment. And why do they do this? This fragmentation of the personalities when there's abuse at a young age. Because in the case of Ms. Stauch, her abuser was also the person that provided her means for survival. A 4, 5, 6-year-old kid does not go out and get a job and work and acquire their own food, pay the electric bill, pay the rent. So while they're being abused, they also, as a matter of survival, have to both hate and love, to fear and placate their abuser / caretaker. how does a person do that? Well, I think in a lot of situations, no one person can do that. That's where the fragmentation personality comes in. All the good and all the bad, all the evil and the hate can't reside in one place. And I know some of you, based on your jury questionnaires, think I'm telling some fanciful tale about this. I get it. I read the questionnaires. But as such, you have sworn an oath multiple times to follow the law and the evidence. Don't like insanity or dissociative identity disorder. That's okay. Joke or an excuse or not valid. That's okay. It's okay if you think that outside those doors. In here, you got to believe it's a legitimate mental health defense, that in fact it exists and that it is scientifically backed. You're going to hear doctors, sworn experts on both sides. So yeah, it's in the DSM-4 or 5, which is the book of psychological ailments and issues psychologists and psychiatrists use to diagnose things. It's listed accepted in the scientific community issue, a real issue, dissociative identity called multiple personalities. Now, whether you believe or their experts believe what our expert believes about whether it was present in this Stauch's case, different issue. But you must, to be fair, impartial, and unbiased, you must believe that it is a possible defense. It is a valid defense. It is a valid defect or disease of the mind that triggers the insanity provisions under the Colorado laws. Laws that trigger when we bring in some testimony or some evidence that there is insanity causes the rules, the laws to pivot. So that the prosecution has the burden of proving beyond a reasonable doubt let's say. In this case, circle back around. Why all of that just matters. Going back to motive. What was with evidence, exhibits, photos, videos. We're going to be in here for 8 weeks. School's going to be out. Making plans for our Labor Day barbecues, not Labor Day, barbecues by the time we get done. But you know what you're probably not going to hear? In all that time with all those exhibits, all that evidence. All those witnesses. You're not going to hear about a motive. You're not gonna be given a motive about why Ms. Stauch. January 2020. Reason is there is no motive. There is no reason. Doesn't make sense. It's insane. Smiling photo. Next day, Shannon's gone. No reason for it. Prosecution may say, oh, well. Makes it that more tragic that it was such a pointless death of Gannon. I don't know. I'm not going to speculate on that. But there was some major psychotic crack that went on during this time. Go from teacher, loving stepmother to 2 children, loving mother to her own child, Harley, a person that Shannon's father entrusted his own 2 kids, watched and loved and by this woman here. Being a killer of an 11-year-old boy. How do you get there? Big jump. There is no explanation for it. I don't have one. She broke on that day, ladies and gentlemen. She broke. Broke from all that was right. Made sense. And the axe, putting Shannon's body in a suitcase and traveling 1,300 miles, whole of Florida, and throwing the suitcase, Shannon's body in it, side of an overpass. Different stories she told. She was raped by somebody. Person who raped her, kidnapped Gannon. Hear all the stories. The prosecution's going to play it for you. These are all signs and evidence of a mind, a soul that is broken. Most fundamental and profound way. So broken, doesn't even know what it was doing. What was going through that person's head? The killer Gannon's head. Stauch's head. All the stab wounds, the shootings, the bruisings, the beatings, the burns. What was going through that person's head? I don't know. I don't know. I couldn't tell you. for the person that she was killing that day, attacking. I wasn't Gannon. Wasn't Gannon to her. Wake up that day and go, I'm gonna. No. She was killing the demons. Her life from the dark depths of her childhood and her life. And here, different doctors. We have a Dr. Dorothy Lewis. She's from Yale. She's been at it a long time. An MD, got a lot of experience with this. Her legal medical opinion is that on the date of this offense, Ms. Stauch was legally insane. Now, the prosecution is going to have some witnesses from our state mental hospital in Pueblo that I imagine are going to say, no, she was perfect. She knew what she was doing. It's normal behavior for a person to do that. Yeah, she had some mental issues and everything like that, but everybody does, but they don't know what he killed an 11-year-old boy. And that is true. A lot of people do have mental health issues. Those talked about in voir dire. Will have very severe mental health issues. They don't go out and kill people. They don't go out and kill 11-year-old boys or their stepsons. They had a nice hike just the day before, as evidenced by that photo. Don't stab the stepson dozens of times. Discharged 3 bullets with a 9mm handgun at the boy, hitting him once, killing him once. Beat him, burn him, and do all these other things you're going to hear about. Wrong, and it's horrible. She not saying. And she will be held accountable. Not guilty by reason and insanity. We'll get a jury instruction. It's about a paragraph long. It indicates in that case, and I think Judge Warner alluded to it, to want a panel of potential jurists in the last couple of weeks. She's found guilty, then it's guilty. She's subject to regular sentencing by the court. But if I'm not guilty by reason of insanity, she walks out of here. She's committed to the state hospital, Colorado Department of Human Services, and they take over from there, state mental hospital. That's not what we're dealing with here now. So I know there is a natural urge, human urge, a real urge. You hear about that little boy with that big bright smile that you saw on the screen. Hear about what happened to him. Want to make somebody pay. Want to make somebody pay dearly. Not right. Happened to that young. Awful. not providing doubt constitutional protections for presumption of innocence, the right to remain silent, placing the burden of proof squarely on the shoulders of the prosecutor, letting bias or sympathy come in and cloud your judgment. Not going to bring Gannon back. Prejudging the case by what you've heard in the media. Would do no good. No, we have a tragedy here. And we know it's terrible. But just listen to the evidence, as I started out with. Don't check out. It's going to be easy. Went into week 6, hearing all these witnesses and looking at evidence. You're going to want to check out. You're going to want to form your decision soon in this case. But you can't do that. For the next 6 to 8 weeks while we're in this trial, can't form an opinion. Werner was telling you that. You're in an evidence gathering phase now. You're gathering the facts. Like Judge Werner's, Miss Denver omelets. This is the ingredient gathering stage. Okay? It's in the cooking stage. When you go back to the jury room after all the evidence is in, you start putting the ingredients together. For omelet, or just a ham and cheese omelet. Whether you've got a guilty, not guilty, or not guilty by reason of insanity, based on the evidence, the ingredients. When you're in the jury room, that's when you start putting it together. Just writing down, taking notes, taking it all in. That's why the judge mentioned several times to you today, I don't want y'all talking about the case amongst yourselves. Kind of a special, hidden, quiet place, this courtroom, especially you jurors. I don't want y'all talking about the case because that leads to deliberating and judgment. It's in the judgment phase. So, thank you for your time. Thank you, everybody, for coming back. We've spent a lot of time together over the next couple of months, so keep an open mind. Put a lot of the bad stuff out of your mind for now. What the prosecution has to say, hear what the defense has to say. At the end of this, as Mr. Allen said, when he's concluded his opening statement, he said, I'm going to come back in a couple months and ask you to find her guilty. I or Mr. Tellini in 2 months. I'm going to ask you to find her not guilty by reason of insanity. Now the trial starts. Had opening statements, you've had all that now. He said, and I said, it's not evidence. Projected up on the board and the videos and the audios that he played. That's not evidence. Remember what the judge said. If you had to deliver a verdict right now, it's not guilty. Woman right here is not guilty. He's presumed innocent. Not telling you to like it. I'm just telling you that's the way it is. I'm going to stop now because I'm running out of steam. But I really, really, really do appreciate your time. I know the judge pays due. Said earlier, you know, you're the ones that are making the sacrifice. You're the ones that, you know, are losing money because you're not able to go to work. That, you know, your workspaces, your offices are idle because you're going to be here for 2 months. What we do, this is where we work, all of us, the attorneys, we pay. They're the ones that make the sacrifice in this case. And I do appreciate it. And on behalf of my attorney, Mr. Tellini, I know he appreciates it. Thank you.
Todd, can you get the last perimeter light, please? I'm not sure which one it is. Thank you. All right, ladies and gentlemen, I want to give you a little bit of roadmap as to what you can expect and where we go from here. As I said this morning, opening statements are not evidence. Their purpose is only to help you understand what the evidence will be. Keep in mind that in this case, as in every case, attorneys are paid advocates. Their job is to persuade you that evidence proves or does not prove a particular point. And as I said earlier, nothing an attorney says is evidence, and they do not take an oath to tell you the truth. Next, the prosecution will offer evidence. Evidence consists of the sworn testimony of the witnesses, the exhibits received in evidence, and stipulated, admitted, or judicially noticed facts. After the prosecution's evidence, the defendant may present evidence in her own behalf, but she is not required to do so. I want to remind you that the defendant is presumed to be innocent. The prosecution must prove the guilt of the defendant beyond a reasonable doubt. The defendant does not have to prove her innocence or call any witnesses or introduce any evidence. At the conclusion of the evidence, I will tell you the rules of law which you are to use in reaching your verdict. I will read those rules of law to you, and you will be allowed to take them with you to the jury room during your deliberations. After you have heard all of the evidence and the instructions, the prosecution and the defense may make their closing arguments. Like opening statements, closing arguments are not evidence. The prosecuting attorney will have the opportunity to reply to the closing argument made by the defense. You will then go to the jury room to deliberate on a verdict. Your purpose as jurors is to decide what the facts are, and your decision must be based solely upon the evidence. It is my job to decide what rules of law apply to the case. You must follow all of the rules as I explain them to you. You may not follow some and ignore others. Even if you disagree with or do not understand the reasons for some of the rules, you must follow them. You will then apply these rules to the facts which you have determined from the evidence. In this way, you will determine whether the prosecution has proven the guilt of the defendant beyond a reasonable doubt. At times during the trial, attorneys may make objections. That's the part in the TV show or movie where one lawyer asks a question and the other one stands up and objects. On TV, the lawyers start to argue with each other, and then sometimes they go up to the bench and they argue with the judge. I know you're going to be surprised, but that doesn't happen in real life. The lawyers in this room have years of experience. They know that the procedure in this case is governed by a written set of rules that apply to all criminal cases called the Colorado Rules of Criminal Procedure. They also know that the evidentiary matters are governed by a written set of rules called the Colorado Rules of Evidence, which apply to all case proceedings, to all cases proceeding to trial. Watch the lawyers, and you will observe that what really happens is that an objection is made, I will ask for an explanation, something like grounds, for the objection, and the response from the attorney will be something like hearsay or foundation or relevance or 404. And most of the time, watch the attorneys closely. Most of the time, the attorneys will state an objection in 5 words or less. There's not a whole lot of arguing that's going on during that time period. And regardless, the argument is never directed to opposing counsel because I'm the one making the ruling and not opposing counsel. So in reality, the lawyers rarely come up to the bench to argue a point because all they need to do is reference the rule, case, or principle they are relying upon for their objection. In any event, the objection simply means that the lawyer is requesting that I make a decision on a particular rule of law. It is the duty of the lawyer to object to evidence which they believe may not be properly offered. Do not draw any conclusions from the objections or from my rulings on the objections. If I sustain an objection to a question, the witness may not answer it. As jurors, you must draw no inferences from the question or speculate as to what the witness would have said if permitted to answer. At other times, I may instruct you not to consider a particular statement that was made. You must not consider any evidence to which an objection has been sustained or which I have instructed you to disregard. Such evidence is to be treated as if you had never seen or heard it. We talked about the notebooks that you have and the juror questions and the process for doing that. They know where to meet, Mr. Combs? They know where to meet in the morning? All right. Give us just a few minutes and we will get you the parking passes. They're on a lanyard, so keep them because that's what you'll need to get in and out of the juror parking lot. The issue about the truck. Haven't solved it yet. And there's a juror that cannot get into the parking garage because of size of vehicle. Who is that? Just raise your hand. Don't leave yet. We'll talk to you. We'll talk to you. I mean, you can leave the courtroom, but don't leave the courthouse just yet. And for the rest of you, it's going to take just a couple of minutes, unless, Todd, you want to run down there on my bookshelf. Do you know where that is? Okay. And so Todd, oh, no, I mean, wait, Todd, come back. It's all good. There. So he's going to get you the lanyards with parking passes on them. Use them to come in, and we will talk with juror number 14 about what to do with your situation. We have a solution. Rachel, are you still here somewhere? Stick around. We need to talk. I think we can use the same solution that we did for the other juror that was coming back at 11. That work? Okay. All right. We have a solution, so just hold on and we will get to you. With that, if I can have everyone, you'll know where to meet Mr. Combs in the morning and how to get into the building. We should be able to start right on time tomorrow at 9 o'clock. What you can expect is that we will start with witnesses. We will take a break for 15 or 20 minutes, somewhere between 10 and 10:30. Then we will proceed on to lunch at noonish, come back 1:15, 1:30, have a break 15, 20 minutes, somewhere between 3 and 3:30 in the afternoon, then recess at 5 o'clock. That's how your day will look every day from here on out. The other thing that you should expect, so that it doesn't catch you off guard, is that every day that we start trial after today, well, I did it this morning actually, but every day that we start trial from here on out, I will ask you a question, and that is, it will be the same question every day. You're going to get sick of hearing it, but it's the same question that I'm going to be asking. Has anything occurred since we were last together that causes any of you to believe that you could not continue to serve as a fair and impartial juror in this case? If so, please raise your hand. So that's why those admonitions that I said about avoiding press, avoiding opinions, avoiding research, all of those things, they all come into play. It's important. This is an important process. So with that, your discharge, we'll see you in the morning. All rise for the jury, please. Right. The only one that I knew of was juror 3. Before you step out real quick, does anybody aside from juror 3 need a letter? Okay. All right. We got it. Thank you. Juror 16 and Juror 3. Thank you. You may all be seated. Record should reflect the jury has left the courtroom. Mr. Allen, I want to clear up one thing on the record. Because I think it's an issue in, where is this? Where's it listed at though? Huh, okay. I just want to make sure that the count that you are dismissing is count 3, child abuse resulting in death.
Correct. So count 1 is murder in first degree. 2 is child under 12. 3 is the child abuse resulting in.
Okay.
That's the one that requires an accumulation of injuries, all that kind of thing. That was charged before Gaynon's body was ever recovered. When Gaynon's body was recovered, we added 1, which is now murder in first degree.
Okay. So this would have been, I'm sorry, go ahead.
It's count 3 of the amended information.
Okay, and that's what I wanted to check on, because the original complaint information that was filed on March 11 only has 4 counts, and count 3 is tampering with a deceased human body, and in that one, count 2 is the child abuse resulting in death.
Are you guys interested in listening to this part?
So it looks like what happened, they didn't realize the amendment, and when they put it in, that's what the conflict is.
The amendment was filed probably March 18th.
I have March 20. Yep. Okay. So what you are proposing to dismiss is the one knowingly or recklessly caused an injury or unreasonably placed in a situation that posed a threat of injury to life, health, or safety by engaging in a continued pattern of conduct that resulted in cruel punishment, mistreatment, and accumulation of injuries. That's the one you're wanting to dismiss.
So count 3 in the amended.
So it's the amended information. That's where the hang up is. Okay, I think we've got that resolved. Okay, so have your witnesses here 9 a.m. tomorrow morning. We should be able to start right on time at that point. And Rachel, I want to talk to you when we're done. Is there anything else that we need to address from the prosecution? Defense? Okay. All right. Rachel, can you come back in the back hallway for a minute, please? All right, court will be in recess. Thank you.
That's a good question, James. I am not sure. I missed the first little part. I couldn't hear it very well. Could you guys? So what do you think is going to happen here? This is going to be a long trial. So 1 shot and 19 wounds with that pointy object. So she then ended up getting like a rental vehicle. Oh, let me turn that off. No. So she did this, and then she hid him. They're thinking maybe in that van. And then that's when you've got to actually her on an interview with a news station. And kind of thinking the vehicle that was beside them may have been where Gannon was. And then she goes out and she rents a vehicle, drops her vehicle off, I think at the airport, goes and rents a vehicle, goes back, loads up Gannon's body, and then drives 1,300 miles and puts him under the bridge in a suitcase, drove back, cleaned the vehicle, gave it back to the rental place, got her vehicle, and went home. So how do you consider that a mental break? Because she did some pretty fancy dancing in order to try and cover her butt. I don't know how that's going to work. But they've got, well, they're thinking up until the end of April. May? Yeah, they're looking a long ways away, aren't they? Before this is going to be over, 4 to 6 weeks, leaning more towards the 6 weeks. Well, and that's the thing, Mexi. And then shows up late for her scheduled police interview with a freshly cleaned vehicle. And I agree with you. I don't think Harley was being honest either. I don't think it's a mental break. It's just not what I'm seeing. I'm thinking she lost her temper, got extremely violent, and then was like, oh, shite. Now what do I do? And she did her best. I'm even concerned about that picture that is of Gannon in bed that morning. So she took a picture of him the day this happened in his bed, sleeping. So they say sleeping. Let me see. I'm going to see if I can find that picture. To me, it's just like eerie. I don't like it. Let me know what you guys think. Why would you take a picture of him sleeping in bed? I mean, just out of the blue. Let me see here. I mean, I did. I'm not going to deny that I did. I took pictures of my son. Of course I did. But it was when, first off, he was younger. And second off, I don't know. This is just creepy. That's all I'm saying. With what ended up happening to this little boy, it just seems very coincidental that she decided to take a picture of him sleeping in his bed. Yeah, super creepy. I don't know, Dandy. I don't know. And, the sad thing is I don't know about the US, but here in Canada, like you go in and they say, okay, you're treated, you're safe now, stay on your medication and everything will work out fine. Go home now, go hang out with society. Does the US do that? If she happens to get a sentence of the insanity plea, so will she go get treatment and then be freed? Or in the US, does she go get treatment and then get put in the Hooskow? Or does she stay in the facility? Here, I mean, we just did that live on the other channel about the guy that was on the Greyhound bus and lost his brain and did some really awful things to the young guy that was sitting next to him on the bus. And go watch it if you haven't seen it. This guy was eventually, well, no, it didn't even take long. He's released. And what he did, I just don't even understand. Nobody can tell me that it's a guarantee that these people will take their meds. So, yeah, he's just not, yeah. And her, yeah, not so smart. Not so smart. So, guys, I am going to jump off. Thanks for hanging out with me. I am not planning on covering the case every day. That's a long go, but I might pop in once in a while when I know things are getting kind of interesting and do a live through that. But the Murdoch trial, honest to goodness, I was exhausted. So thanks, guys. I appreciate you. I hope you enjoyed the tail end of it anyways. I'll see you guys in the next one. Bye.